The Patents Act 1970. As we just mentioned, this course will be taught based on statutes. So, our entire focus during this course is going to revolve around the Patents Act 1970, the corresponding rules, and two other enactments, but we will have only some passing references made to those two enactments concerning the practice before the Intellectual Property Appellate Board. To understand the Patents Act, we can look at the timeline of the grant of a patent. The timeline can be defined or described in the form of a diagram. The starting point of the timeline is what we refer to as TA, that is the time of application of a patent, and the end point of the timeline can be explained as the time of expiry of the patent. So, the life of a patent is actually between these 2 points. It is between TA and TE. On an ideal case, when a patent is granted, it can survive. The patent has a 20-year term. So, TA to TE in an ideal case is going to be 20 years. So, 20 years is the patent term, and we have just described this timeline for you to understand how we can understand the Patents Act as provisions which can be shown or which come into play between these two timelines. So, the entire Patents Act, the enactment that governs the law of patents in India, can be understood as interventions between TA, that is time of application, and between TE in the life of a patent. Now, let us see how that looks. The patent normally takes on an average 3 to 6 years for it to get granted. So, from the day you apply the patent, that is from TA up until TG, that is the time for the grant, you have roughly, and this is not set on stone, it varies from application to application, and it could also be, it could vary from patent office to patent office. So, on an average, we could say that the time between filing the application, the time of application, and the time of grant. The grant is when a patent is granted by the patent office. So, this time period takes roughly 3 to 6 years, and the sections in the Patents Act that govern this stage, that is from TA to TG, are largely sections 1 to section 81. Okay, 81. So, when we refer to the events that happen between TA and TG, we are also looking at certain events that happen immediately upon the grant, upon TG. So, it is not just the time for the grant, but also certain events that can happen immediately upon the grant or soon after the grant. So, if you need to draw a line demarcating the patent office's functions, then it will be around section 81. So, anything before section 81, that is section 1 to section 81, are events that happen at the patent office up until the grant or soon after the grant. From TG to TE, that is soon after the patent is granted by the patent office, the patent has its remaining life, and this time period is what we call the time in which a patent is enforced. Patent enforcement happens between TG and TE. Now, when we say patent enforcement, we are referring to the patentee, the right holder, the patent holder exercising his right in the patent. Now, that could come in the way of licenses. When a patent is granted, the patentee has the right to license his technology, license his invention. It also pertains to measures that the patentee can take to prevent others from interfering with his right. So, when somebody else interferes with his right, we call that an infringement. An infringement is an act that intrudes into the right of a patentee. The patentee is granted certain rights under section 48 of the Patents Act. He has a right, an exclusive right to exclude others. So, it's a right to exclude actually. He has an exclusive right to exclude others from making the invention, from selling the invention, from offering for sale, from importing, and for using the invention. Now, the invention can be a product or a process, these details are mentioned in section 48, but largely any intrusion on these sets of rights by a third party without the consent of the patentee is what we refer to as infringement. So, infringement and licensing. A licensing is a positive act where the patentee allows his invention to be used by others, in most cases for a royalty, and infringement action, which is an action taken by the patentee to stop persons who don't have his consent from using his invention. These two acts can together be called patent enforcement, the way in which a patent is enforced. Soon after the time for grant, there is a proceeding that can take place in the patent office, which is called a post grant opposition or opposition after the grant. The language used in the Patents Act is opposition after the grant, but it is in common parlance, it is also called post grant opposition. Though post grant opposition happens immediately after TG, that is 1 year after TG, that is the timeline for the post grant, the provisions of post grant are mentioned in section 25(1). So, that is an exception to this middle line that we have told you, that anything before 81 pertains to patent prosecution, things that happen in the patent office, and anything between TG and TE, that is section 82 to 160, that's the so section 1 to 160 covers the entire ambit of the Patents Act. So, anything between 82 to 160 will happen outside the patent office. So, this timeline has some exceptions. One exception is what I mentioned, post grant opposition, which happens soon after the grant. So, that is why I qualified my statement earlier saying that the timeline between TA and TG should be understood as events that happen at the time of grant and soon after the grant. So, to recap, TA to TG are events that happen within the patent office, and when we say TG, we are also referring to things that happen soon after the grant too. So, the patent office can look at certain things that happen soon after the grant or which are related to grant. For instance, compulsory licensing can happen any time between TG and TE, but still because it is a procedure at the patent office, you will find that it is mentioned after section 82, but nevertheless it is considered as a patent office procedure. Now, the events that happen between the timeline between TA and TG normally happens at the patent office, and the events that happen between TG and TE, that is the time of grant and time of expiry, could happen before the district court, before the high court, or before the IPAB, that is the Intellectual Property Appellate Board, the board that sits in appeal over decisions of the patent office. Now, let us look at a rough list of things that happen between TA and TG, because if you are going to take the patent agent examination, then the patent agent examination largely focuses on this part of the Patents Act, though there will be questions on what happens between TG and TE, but largely it is going to be between section 1 to 81 with some exceptions too. We will cover the exceptions later. The events that happen at the patent office between the timeline TA and TG are referred to as patent prosecution. Now, during this timeline, you have the sections in the Patents Act deals with a variety of things. Patentable inventions are described in sections 3 to 5. Patent applications are referred to in section 6 to 11. The procedure for opposition is mentioned in section 25 to 28. This includes pre-grant and post-grant. Post-grant is something that happens at the patent office 1 year after the grant. It can be initiated within 1 year period after the grant. Then you have the provisions on anticipation, the exceptions to anticipation in sections 29 to 34. We have secrecy provisions in sections 35 to 42. Then the grant of the patent, there are sections covering the grant, because grant could be seen as the TG starts with the grant, but there are provisions which go beyond the grant too, because we mentioned that things that happen upon the grant and soon after the grant could come under the TG. So you have grant of patents covered under sections 43 to 53. Then we have amendment at the patent office, that's section 57. Then restoration of lapsed patents for non-payment of renewal fees are covered, again a procedure at the patent office. These are covered in section 60 to 62. Then the patent office maintains a register of patents that's contained in sections 67 and 72. Then the patent office has certain powers and functions. The structure of the patent office, these are covered in sections 73 to 76. And the powers of the controller in general are covered in sections 77 to 81. Now, this is not an exhaustive list, because as we mentioned before, patent prosecution can also go beyond section 81 in few cases. The exceptions where the patent prosecution can go beyond section 81, or rather the exceptions where there are certain acts between section 1 and 81 which do not pertain to things that happen between the timeline TA and TG, are the following. Post grant opposition under section 25(2), though it comes between sections 1 to 81, it actually happens after TG. Though at the patent office it happens, the time for it occurring is after TG, because a patent to be opposed under post grant opposition, it has to be granted in the first place. So you find that post grant opposition is an exception in the sense that it's an event that happens after the grant, so it comes after TG. Similarly, patents of addition, though it is mentioned under section 54 to 56, which again comes within the sections between 1 to 81, are events that happen after the grant. You could only file a patent of addition if you have already filed a patent in the first place. Amendment under section 58 is not an amendment that takes place before the patent office. It's an amendment that can take place before the Intellectual Property Appellate Board or the High Court. Though it comes within sections 1 to 81 in the scheme that we had mentioned, amendments are at the IPAB or the High Court happen after TG. Surrender and revocation, which are covered in section 63 to 66, can happen only after the patent is granted. Again, these events happen after TG. So on a whole, TA to TG is governed by sections 1 to 81. You have few exceptions where the sections between 1 to 81 may have its impact after TG, after the grant of the patent. So this timeline, the timeline between TA to TE, the time of application of a patent to the time of expiry of a patent, can be used to understand the entire syllabus of the Patents Act. So you have broadly sections 1 to 81 covering the events up unto the grant, what we refer to as TG, the time for grant, and soon after the grant you have sections 82 to 160 which cover the events that happen after the grant. The events between TA and TG are referred to as patent prosecution, things that happen at the patent office, and the events that occur between TG and TE are referred to as patent enforcement, events that happen in the district court, the high court, or the Intellectual Property Appellate Board. We just saw how the Patents Act can be understood by looking at the life of a patent. The life of a patent starts with TA, that's the time when a patent application is made before the patent office, and it expires ideally after a period of 20 years at TE, which is the time for expiry of the patent. Now, this timeline is mimicked by the Patent Act itself. The Patent Act, the initial sections start with how to apply for a patent, and towards the end the Patents Act talks about powers of various authorities involved in the patent system, and it also talks about how the government can acquire and use. So you have the entire Patent Act structured around the life of a patent. And the life of a patent, as we had shown diagrammatically, is described as events that happen between the time for application of a patent TA and the time for expiry of the granted patent TE. The patent rules 2003 also follow the same pattern. The patent rules are nothing but details of the provisions contained in the Act. The rules describe the details of the provisions contained in the Act. So, the Act follows the same structure. Since the Act follows a particular structure, the rules also follow the same structure. So, if you look at the index of the rules are also structured in the same manner. So, you could also classify the rules the way in which we have classified the Act, as something beginning with application and ending with expiry. The Act and the rules were amended a number of times, and these amendments, the amendments that we really need to focus on, are amendments that came about after India became a member of the World Trade Organization, WTO. So, when we became a member of the WTO has an agreement on intellectual property rights called the TRIPS Agreement, which stands for Trade Related Aspects of Intellectual Property Rights. The TRIPS Agreement brought about certain changes in the intellectual property regime of its member nations. All member countries of the WTO were required to have certain common minimum standards on intellectual property rights. With regard to patents, it meant, among other things, that all countries will grant a universal patent term of 20 years. Earlier, different countries had different grant times. Now, after the coming into force of the TRIPS agreement under the WTO, all countries who are members to the WTO grant a patent for 20 years. So, the term of the patent is now universal in that sense. So, India had to carry out various amendments. So, the Patent Act was amended in 1999 to bring about certain provisions. Then again there was an amendment in 2002, and the last amendment came in 2005. So, with the 2005 amendment, the Indian law was in complete compliance with the obligations under the TRIPS. Now, why did we do it in 3 sets of amendments? Little bit of history will tell us that India had actually taken the benefit of a transition period, which allowed some developing countries to bring their laws in compliance over a 10-year period. So, the TRIPS agreement under the WTO allowed developing countries to bring in the compliance in a phased manner. So, we took advantage of that provision, which gave us a 10-year lead time to bring the amendments in place, and that explains why we had this phased amendment. Around the same time, the rules were also amended. The patent rules were amended in 2003, and they were again amended in 2005. Now, the 2003 was a overhaul of the earlier rules. The earlier rules were the patent rules 1972, and this was completely overhauled, and in 2005 there were some amendments to it. Importantly, after 2005 there has been a series of amendments. We had an amendment of the rules in 2006, we had an amendment in 2013, and again in 2014 and in 2016. Now, if you look at an updated version of the rules, you will find these amendments mentioned in various footnotes. So, when you see an updated copy of the rules, you will be able to see which amendment came at what time. So, what were the amendments brought by the 2014? The footnote will tell you the detail. Now, what does this tell us? Why is it that before 2005 the Patents Act had to be amended 3 times, and whereas the patent rules were amended only twice, but after 2005 we have had 4 further amendments of the rules and not of the Act. Now, this tells us the structure in which the patent laws are designed and enforced. The acts are passed by the Parliament. So, they are central legislations passed by the union government, whereas the rules are rules made by the central government. They are not like the act, they are not prepared in the form of a bill and placed in the houses of parliament for approval, and then it does not require a presidential assent, whereas rules can be made without going through this process, and it can be created by the central government internally. It is something, it's a process that is internally driven. Because act requires the parliament to pass it, the acts are written in a very broad language. Wherever you need to have some details, they would leave the rules to prescribe the details. So the act can be understood as something which gives the broad rules, whereas the rules are descriptive of the details that were not described in the act. So we understand the rules as giving the details of the things that were not mentioned in the act. We will look at a few examples in detail. The structure of the Patents Act. The Patent Act comprises of various sections. So the smallest unit of the act are the sections. The Patents Act comprises of sections from 1 to 162. We have this sections of the Patents Act. 162 is actually a repeal and savings provision. So that's the reason we did not mention it in the earlier timeline. We had stopped at 160 because 162 is a repeal provision. As we mentioned, Act is a creation of a parliament. It takes its life in the form of a bill. The bill is presented before a house, then it moves to the other house, and later it receives the presidential assent. Rules. The basic unit of the rules are the rules themselves. You have 139 rules in the Patent Rules 2003, and we have 5 schedules. The Patents Act also has one schedule, but that one schedule refers to the amendments to the Indian Patents and Designs Act 1911. It's a schedule to the Patents Act refers to the repeal and savings provision. So that's not something to worry about. It pertains to amendments to the Indian Patents and Designs Act 1911. The Patent Rules 2003 comprises of 139 rules and 5 schedules. The first schedule and the fifth schedule deal with fees, the official fees that has to be paid before the patent office when an application is prosecuted. Table 1 talks about fees payable for various events. Table 2 talks about the fees that are refundable, and we are talking about the first schedule. The first schedule is further classified into Table 1 and Table 2. The fifth schedule talks about fees for international application. So, of the 5 schedules, 2 schedules, that is the first schedule and the fifth schedule, deal with fees, either fees filed before the domestic patent office for local patent applications, or what we call Indian applications, or for international applications. The second schedule lists the various forms that an applicant needs to use while filing things before the patent office. So we have different forms. There is form 1 for filing a patent application. There is form 2, which is the form for the complete specification or the provisional specification. You have various forms. The second schedule has 31 forms, and it's important to know these forms because we need to understand what form can be used for which procedure for doing certain things. The third schedule describes the form of a patent. When a patent is granted, it is granted on this form. We soon looking at the form. The form of a patent is the certificate of the grant. The grant is made in the form that is mentioned in the third schedule. The fourth schedule deals with a scale of costs. In certain proceedings before the patent office has the power to award costs to the succeeding party. If there are 2 parties and if one party succeeds, the patent office can award costs to be paid by the losing party to the succeeding party. So it gives the scale of costs. These are the how to compute the cost so that there can be a order on costs. As I mentioned before, the rules provide the details. For instance, if you take section 8 of the Patents Act, section 8 deals with information and undertaking regarding foreign applications. You will find in some places the act says, I am reading from section 8 subsection 2 towards the end, and in that event the applicants shall furnish to the controller information available to him within such period as may be prescribed. Now, what this prescription is not there in the act. What is the period that as may be prescribed is not mentioned anywhere in the act. The period as may be prescribed is mentioned in the rules. The reason for that is, for some reason, if this period needs to be changed, it can be done by a simple process of the central government making or amending the rules. It need not go back to the parliament and there not be a presidential assent to that process. So that is why you find this generic language repeated in various parts of the Patents Act, as may be prescribed, within the prescribed period, within the time prescribed. Now, all these variations are used so that if you need to change the law, there is no need for you to go back to the parliament and to get bill moved in both the houses of the parliament, followed by getting the presidential assent. So, the rules are designed to fill in these gaps which may be required as times change. For instance, you can look at the fees in the first schedule. The fees will constantly change as inflation soars up or as the economy grows. The fees structure will have to change. So, that structure of changing the fees can be done by changing the patent rules rather than the Patents Act. So, wherever you find this language in the act, as may be prescribed, within the prescribed period, within the prescribed time, you will find that there is a corresponding reference to the details, how many months or how many years, in the rules. And this is largely to ensure smooth functioning of the patent system, because amending the act is a problem in the sense that the procedure is a detailed one and it takes time to amend the act. Now, the rules also contains a wide variety of details. The rules, one, at a very broad level, it describes these generic phrases as may be prescribed, the timeline or the fees that is prescribed, you will find it in the rules. So, any timeline that has to be maintained, most likely to file that timeline described in the corresponding rules. The fees that have to be paid will again can be found in the rules in schedule, the first schedule or the fifth schedule. The patent rules also describes some details which normally you will not find in the act. For instance, if you want to know what should be the margin space in a specification, you will not find it in the act, but the rules does mention that. What should be the fee payable for filing complete specification? Again, the fee can vary if you are a individual, it can vary if you are a small entity, it can be a different fee if you are a corporate entity. So, all these details you will find it in the patent rules. And because rules are not passed by the parliament and because they are made by the central government, it gives the flexibility for the central government to come up with the rules as and when they are required. Now, the power for the central government to make the rules is contained in the Act. Section 159 of the Act gives the power of the central government to make rules on a host of things which are mentioned in subsection 2 of 159. So, the power to make the rules was given by the parliament to the central government through section 159. And if you see the patent rules in the first page of the patent rules, you will find in the preamble a statement, therefore, in exercise of the powers conferred by section 159, the central government hereby makes the following rules. It's a standard statement. So, if you look at the rules, you will know that the rules are what we call delegated legislation. They are derived from the Act. The Act gives the power to make the rules, and because the Act gives the power to make the rules have to be within that framework. The rules cannot go beyond the framework. For instance, the rules cannot change the term of a patent. The term of a patent is mentioned in the Act, and as I just mentioned, this is something which India had to comply with because of the obligation under the WTO. So it was an international obligation that got incorporated into the Act. The rules cannot now make the term, they cannot lessen the term or they cannot increase the term, because the rules can only do things for which there is authority given under the Act, and the authority you will find in section 159 on the things for under which the central government can make rules. In that sense, this is what we call delegated legislation. The rule making power is delegated to the central government. Because they are delegated, rules are passed after the Act is passed. For instance, when the Patent Act came into force for the first time, this was in the year 1970. The corresponding patent rules, the patent rules in 1972, came 2 years later on. But you could also have instances where the Patent Act and the rules come simultaneously, but the rules can never precede the Act. The reason why the rules contain the detail is that there is no need to amend the Act to change the details. One of the recent amendment that came in the year 2016 was the Patent Amendment Rules 2016. Now, this contained many details on startups, small entity, how expedited examination of certain applications can happen, how you could withdraw an application and get refund of fees. Various details were covered in these rules. Now, the rules can be amended any number of times, and as I mentioned, because it can be done by the central government and there is no need to seek a file to pass a bill before the parliament, it becomes easier for them to pass the changes by way of amending the rules. And we have already seen that there are cases where the Act will not mention the details. The Act will just broadly phrase it in a broad language as may be prescribed within the time prescribed, and the details will be mentioned in the corresponding rules. This gives the patent office and the patent system the operational flexibility, and as I mentioned before, the rules cannot exceed the mandate of the Act. Apart from the Act and the rules, now we saw the Patents Act 1970 and the Patent Rules 2003. There are certain details mentioned in what we call the patent manual, patents manual. Now, this is called the Manual of Patent Procedure and Practice. It is MPPP or MP3. Now, we will have reference to the patent manual in various places during this course. The manual, the latest version of the manual is available at the Patent Office website. It does not have the force of law. The manual at best can be regarded as guidelines on how the Patent Office operates, how the Patent Office procedures are, and the manual explicitly mentions that it is not binding on the Patent Office. So, we cannot use the manual to force the Patent Office to take a particular decision in a particular way, because the manual is a guideline of probably the best practices or the practices that is followed by the Patent Office. So, if it does not have the force of law and the last manual available is not updated in line with the Patent Amendment Rules 2016, though we hear that the new version of a manual could be out anytime. So, if it does not have the force of law and if it is not binding on the Patent Office, then why do we need this manual? Now, the manual contains details on certain guidelines, and it's important to understand these guidelines because these guidelines throw light in cases where the Act and the rules are silent. So, we look at the patents manual, the Manual of Patent Procedure and Practice, as a document which gives us information on issues where the Acts and the rules are silent.